Okay, guys. So we were talking about preamble, and I hope you need to go with that each and every words like liberty. When we talk about liberty, what does that mean? It is actually against the arbitrary action of the executive, or it can be against the legislature also. Okay, so if the law which is made by the legislature is not good, that also can be struck down. Like you can go with due process of law. I'll come to this, guys, when we discuss about fundamental rights. Okay, so liberty means, when we talk about liberty, that is basically against the arbitrary action of the executive. Similarly, fraternity means brotherhood, right? So equality, when we talk about, it is the equality in terms of status and opportunity and everything. So that is the reason why when we discuss about fundamental right, we will talk about equality before law and equal protection of law. Both are slightly different. Okay, so justice, as I've discussed already, it is social, economic, and political justice. Republic, the people are supreme, right? The head of the state is actually elected. Like in UK, if you see, it is a monarch which is not elected. That is what we mean by a republic. So I hope that part is clear, and you can read that, and they can ask you what is the meaning of liberty, what is the those kind of specific questions also can be asked. Okay, that is the reason why I told you to read that. So now I've told you we will be discussing briefly about the types of majority if you have any doubt. So the first one is related to simple majority. What is a simple majority? Suppose 100 members are present, 51. Okay, so like 545 is the capacity, or the seats are available, or the total number. Okay, but out, let's suppose 300 are present, then what does that mean? 151 is the simple majority. So simple majority means, out of the number of MPs who are present and voting, more than 50 percentage, okay, or not less than 50 percentage of present and voting. Okay, so this is just 50% of present and voting. That means if 100 people are present, 51, that's what simple majority. Okay, so out of the number of people who are present, this is the total capacity, the total number of the members of the house. So if suppose 300 are present, 151, 100 are present, 51, this is simple majority. Okay, now what do you mean by absolute majority? Absolute majority means it doesn't matter how many are present or not, it is the majority of this total capacity. What is that? 545. What is the majority? That is 273, right? So this is the majority. So absolute majority means not less than 50 percentage of total. Here, not less than 50 percentage of present and voting. So can I say absolute majority is something which is fixed? Yes, this is fixed, right? But can I say simple majority is something which is varying? Right, it depends on the number of members who are present and voting, that will be varying. Then what about effective majority? Effective majority means there is a small alteration from absolute majority. So here there will be total, like how much is the total? 545. Out of this, let's say 5 seats are vacant. So total minus vacancy. Now how this vacancy can come? It can come with the death of MP, or resignation of MP, or disqualification of MP. So how much is the effective strength now? 540. That is what you will see here. Effective majority means this is the effective strength after ignoring the vacancy, and 50% of this. What does that mean? 271. Okay, so I hope you got the difference between this two. Here, absolute majority means it is 50% of the total, not less than 50% of the total. Here also, not less than 50% of total minus that vacancy will guys, this is absolute majority, so that, because that is the total. Effective majority means effective number of members, MPs are how many? You cannot take this 5, right? Because they are not part of it. So that is what simple majority, not less than 50% of present and voting. Absolute majority, not less than 50% of the total. Effective majority, not less than 50% of the total minus vacancies. See, that you will exclude the vacancy, so you'll get the effective MP number of members, and then take majority, 50% of that. Then what is special majority? Special majority will come along with one of this also. When I say special majority means 2/3 of present and voting. So when you consider the number of members who are present and voting, you need 2/3. But at the same time, this should be of this. So what does that mean? In whenever you are saying the special majority, it definitely has to be more than 273. Okay, it will definitely be more than 273. At the same time, 2/3 of the members who are present and voting. So let's suppose 100 members are present and voting. Now, what is 2/3? 66. Can this be considered a special majority? No. Why? Because this is not satisfied this condition of absolute majority. Absolute majority, it has to be more than 273. That is when we are discussing about special majority. So it will be clubbed with 2/3 of members present and voting, and then absolute majority. This is required. Okay, so this is what I've discussed with you in some of the provisions of the constitution. Why we are saying rigid? Because you need a special majority, right? So this is what the concept of special majority. So I hope this majority part is clear. Now what we will do, we will move to part 3, which is fundamental right, part 4, that is directive principles, and part 4a, that is fundamental duties. These three are very important, guys. Fundamental duty, there is nothing to discuss. That we will cover first. So this is part 4a. Which amendment? 42nd amendment. Is that there in the original constitution? No. Fundamental right originally not there, so it was added in the 42nd Amendment Act of 1973. Which committee? Swaran Singh committee recommendation. Okay, actually, how many are there? 51a clause a to 51a clause k. So which article? Article 51a. Only, how many articles are there? Only one articles are there. Okay, so 51a clause a to k. How many are there? 11. So total, how many fundamental duties are there? 11 fundamental duties are there. How many articles are there? Only one article is there. How many was there in the beginning? 10 was there in the beginning. One more was added later. What is that? 86th amendment. I hope you all know about 86th amendment, which also added a fundamental right, fundamental duty. It is a duty of the parent to send to the school the children 6 to 14. Okay, and then it also added under this article 21a, which is a fundamental right, and there is this modification which is done on DPSP also. Okay, so 86th Amendment Act, it will have impact on fundamental duty. Yeah, right to education, fundamental duty. 11th one was added. 21a, fundamental right. One DPSP also is connected to that. Okay, so that is 86th Amendment Act. Guys, all these fundamental duty, just go through like scientific temper. So many things are there. These 11, they can ask you which among the following are the fundamental duty. If you get these kind of questions, these are the easiest ones which you can get, and never miss out. Okay, and never make any mistake also. Once you make mistake in this kind of questions, I think this was asked in 2014 or something, directly fundamental duties are asked. And not only that, year many times I've seen these questions. So in case if you're getting this, these are the questions where you cannot take any excuse. So hardly 11 is there. You don't even want to mug it up. You can see the option, you will be in a position to understand. Okay, so these are the questions which you should never miss, and there is no excuse for you cannot crib after missing these questions. Okay, I've seen people cribbing by seeing I know this but I marked it wrong. There is no point in doing that. Criticism and all is not required at this juncture. I'm not discussing that. Now we will talk about fundamental rights. Okay, like this is the part 3 of the constitution. So guys, what is the difference between fundamental rights and constitutional rights? Constitutional rights, like if this is constitution, like we can say this is fundamental rights. Okay, so there are certain rights are fundamental, but there are some other rights which are seen in the constitution. These are fundamental rights. Upon the violation of these fundamental rights, you can directly approach Supreme Court under Article 32, which in itself was a fundamental right. Okay, but other rights, if it is violated or any issues there, you need to go to the High Court under 226. That you cannot directly go to the Supreme Court. That is the main difference. So there are many other rights. These are constitutional rights. Why it is constitutional rights? Because this is guaranteed given by the constitutional right. This is guaranteed by the constitution, but this has been specifically under the fundamental right. So you can go to the Supreme Court for the enforcement of the fundamental right. No, right to education is there in the fundamental right. So if the it is a right to, it is a right to the children, right, to get educated under 6 to 14, but you they will get it. The state cannot come and take you from the home, right? It is the duty of the parent, so that duty should also be there. It is the duty of the parent, but fundamental duties are something which cannot be enforced. Okay, so that is required anyway. Right to constitutional remedies. So here mainly fundamental rights are violated, you will directly go to the aggrieved person can directly go to the Supreme Court. So if you are moving to Supreme Court for any violation, for example, somebody is discriminating, right to equality you are challenging, you can either go to 226, you can go with the High Court, or you can go with the Supreme Court. So if suppose you go to the Supreme Court, okay, the Supreme Court cannot ask you to go and get it from High Court in case of fundamental right. But in these rights, you go to Supreme Court directly. The Supreme Court can ask you, you have effective remedy here, first go there and approach the High Court under 226, and then as an appeal, this is an appellate court. But in case of fundamental rights, Supreme Court have an original jurisdiction. So right away you can go to the, which in itself is a fundamental right. Okay, so that is the main difference. Okay, so I hope you understood. Then there are some other legal rights, statutory ordinary legal rights are there. So that is like extra constitutional rights, right? This right to food, right to work, MG and REGA, that guaranteeing you around 100 days of work. These are not constitutional rights, these are not fundamental right also. These are some legal rights or statutory rights or extra constitutional rights. So these are the three different. Right to what is a legal right? This question was asked before, I think we have discussed it in the class before, okay, with the polity students. So right to what is not a fundamental right, not a constitutional right. There is a some of the, so even I also had this confusion that year. If I would have seen this question, I would have thought about this 326 at that. Now guys, everybody know. But imagine this question which came in, I don't remember the year when it came. As soon as you see this question, what will come to your mind is this is related to 326, and 326 is giving you universal adult suffrage. Nobody is actually thinking about Representation of People Act, but this was in the news that related to election or something. That news was there and it has been clarified also. Some discussion was there. That is the reason why this question was asked. Otherwise, now everybody know why, because you have got this question, and once you got the question, this debate and discussion and solution and keys are there. So it is even that year also. If you look into immediately after the exam, if you look into the keys, there were disputes. Most of the answer keys were talking about constitutional right, because they are interpreting 326 universal adult suffrage is giving you rights. No, actually the rights, you can challenge it under Representation of People Act only. That is why it is a legal right. Okay, our point is not about that. We will be discussing about this fundamental rights. Okay, so from where it is borrowed, it is like it is inspired by Bill of Rights in American Constitution. Okay, so in fact this part 3 and part 4, that is fundamental rights and the directive principles of state policy, is actually considered as conscience and intellectual component of the Constitution. This fundamental right is what something which enforce this rule of law. So if you remember when we discussed about constitutionalism, one of the most important aspect related to constitutionalism, what I've told you, is the fundamental rights. Okay, the very first fundamental right, which is related to equality before law and equal protection of law, which is totally connected to rule of law. Okay, that is also one essential component of constitutionalism, a constitutional democracy. Okay. Now, one more point. Fundamental rights will provide you the protection only against state action and not against the private individual action. Okay, but except there are 3 cases, like abolition of untouchability. This against private individual also. Similarly, right against exploitation, right to life. So these are the 3 cases from where you can claim against private property also you have a fundamental right. Otherwise, this can be only against the state. It will protect you from the state only. Okay. Now, with respect to these 13 clause 1 and 13 clause 2, we need to discuss this. So article 13 clause 1 is actually talking about pre-constitution law. Pre-constitution law means before 26 Jan 1950. Okay, so what is this saying is, it's actually any law, like any pre-constitution law will be scrapped if it is violating the fundamental right. What about article 13 clause 2? It is talking about post constitution law. It is crystal clear, guys, right? Any post constitution law which is violating the constitution, it will be declared null and void. It will not be valid. Okay, so now, what is this concept of doctrine of principle of eclipse? This case, Bikaji Narayan, state of MP. I'm just writing. You can write state of MP, or guys, if you cannot remember this one, MP. Suppose if you're writing a mains answer, in case if you need to write any particular state, you just write state. Okay, so this is enough for you. Normally in all these legal proceedings and all, even if you see the lawyers who is arguing the cases, you will only see in the courts it will be discussed like this: Bikaji Narayan versus state. It will be taken as a reference, right, for the next case. So they will only use like this only. They will not say state of MP or anything like that. Bikaji Narayan versus state. So this is how you can, in case if you forget, if you can remember, it will be fine, because many cases I'll be discussing soon. So some will come in MP, some cases will be related to Punjab, we will discuss, right? And then we'll discuss about Kerala. So rather than avoiding that confusion, you can just use state. Even if you know this name, I don't think that you will forget these names, right? Bikaji Narayan or Kesavananda Bharati, etc. You can just take it as state. It can be, you can even write it as even for Government of India also you can write state. Even for Union of India, uh, anything you can write a state, no problem. Okay, simply write, even if it is at the state level, Kerala or Tamil Nadu, you just write it as state. Union level, still you write it as state, in case if you have any confusion. That's what. But if you know it very clearly, then go ahead with the state of MP. Okay, so in this case, it is in 1955, Supreme Court applied the principle of eclipse and said that what happened is, in the pre-constitution law, these laws will remain dormant or remain under the shadow of fundamental right. Okay, that means you don't want to scrap this law, let it be there, but it will be under the shadow of the fundamental right. If there is any modification which is going to happen in the fundamental right, or if there is any amendment which is going to happen with respect to this law, which will clear this clash between fundamental right, then it will become operational. So as of now, you don't want to scrap this law. That is what this concept of eclipse, okay, principle of eclipse. But with respect to post constitution law, in this case, which case? Deepchand versus state. Okay, so guys, this is what I've told you. Just remember these names and write state. If you need to know specifically state of UP, it has been held that this principle of eclipse or the doctrine of eclipse can be applicable only in pre-constitution law. That is what we have discussed here. Why it is not applicable in post-constitution law? Because when the law came or passed, then itself it is violation, right? So that is not, this is a word which is used, ab initio. They are void ab initio. That means in the beginning itself, when the law enacted itself, it is actually a violation of constitution. So it cannot be, there is no need of eclipse or anything. It has to be struck down. But this is something which has been made in the past. Okay, so let it keep it dormant or behind the shadow of the fundamental right. If there is any change which is happening in the fundamental right, or any amendment which is happening here, and if that clashes over, then no problem. But here already the constitution is there, and then violating the constitution, if you have made this law, then ab initio, in the beginning itself it's wrong. So there is no need of this principle. So these two cases, Bikaji Narayan versus state, Deepchand versus state. But in the next case, which case? Ambika Mill case. Ambika Mill versus, guys, I'm telling again, state. Okay, you can write it as state of Gujarat. 1974. This is 59. This is 55. Okay, this is 55, 59, 74. In Ambika Mill case, it has been held that this principle of doctrine of eclipse can be applicable in the post-constitution law also. Okay, so with what I was discussing is related to the principle of eclipse, and three cases I've discussed: Deepchand, and then these are the three cases, right? This is Bikaji Narayan versus state, Deepchand versus state, Ambika Mill versus state. So Bikaji Narayan, it will be doctrine of eclipse is applicable for pre-constitution law. Deepchand says not applicable for post-constitution law because law itself is invalid. Ambika Mill says it is applicable to post-constitution law. Okay, so that's about this principle of eclipse. Now we will also quickly see the amendability of fundamental right. Okay, for example, if you see one of the fundamental right, Article 15, Clause 1, what is this? Don't discriminate. Guys, I will not be discussing all the fundamental rights. The key points I will cover. You need to look into each and every fundamental right. They can frame questions from each and everything. There is no point and there is no time here. We have to discuss about all these fundamental rights. Okay, so 15, Clause 1 says what? There should not be any discrimination. But you will see 15, Clause 4. This is actually added later in the First Amendment. Okay, so First Amendment of 1951 added this one. What is this 15 Clause 4 actually saying? The state can take steps to uplift socially and educationally backward sections, right? So state can take, that means reservation. So this is giving way to reservation, but reservation is a different article, but this article is actually giving way to reservation for a larger public interest. So this is actually, in fact, you can see 15 Clause 4. Similarly, 19 Clause 6, this is also going against right to vocation. Okay, so these are actually the coming under 13 Clause 2, right? The post constitution laws, which will be what 13 Clause 2 says: post constitution law, if it is violating constitution, then it will not be valid. So here this is an amendment, right? First Amendment. So what has happened is this has been challenged under which case? Shangari Prasad case. Shangari Prasad versus state, or you just write Union of India. Okay, so in case if you have any confusion, always write state, but Union of India, if you can differentiate at least, then it will be fine. But state is also fine, no problem. Okay, so in Shangari Prasad case, what has been challenged is under this ground. 13 Clause 2 says post constitution law will be struck down if it is violating constitution. But here the judgment was in favor of parliament. The reason why it was in favor of parliament is because the parliament has two type of legislative power. One is ordinary legislative power, and then constitutional amendment, right? So ordinary legislative power means the normal lawmaking which has been done in a simple procedure with simple majority, can have a joint sitting and all. But constitutional amendment, no, there is a rigid process, right? Like a special majority and special provisions, etc. Now what about this one, 15 Clause 4? Is this a ordinary law or a constitutional law? 15 Clause law 4 is actually a constitutional amendment. Okay, so what has been held in the Shangari Prasad cases, if it is a ordinary law and if it is violating the constitution, it will be declared null and void. But that is what actually held under 13 Clause 2, right? Any post constitutional law, that law refer to this one. But what is this Article 15 Clause 4 which is challenged in the Shangari Prasad case? It is not a law which comes under 13 Clause 2. That means this amendment is not a violation of this one, or it will not come under this. Why? Because there's a constitutional amendment which is done with a special majority, that is not coming under this. Article 13 Clause 2 will attract what? Laws which is made after the constitution. But this is not a law. What is this? This is an amendment, and parliament have the power to amend constitution under 368. So parliament can amend any part. So this is what the judgment in this case. Okay, so I hope this is clear. Shangari Prasad case, it has been held that this one is not, Article 15 Clause 4 is not a violation of 13 Clause 2. Why it is not a violation of 13 Clause 2? Because this 15 Clause 4 is not a law. It is a constitutional amendment, and it is valid under Article 368 of the Constitution. Okay, that is a Shangari Prasad case. But after that, there is another famous case, guys. There are you will see different judges will come up with different judgments, right? And some of the cases will hurt the ego of the judges also. Judges are also human being, so if the ego of the judges are hurt, they will also come up with modification. They will also innovate something. And in Golaknath case, what happened is Golaknath versus state. Okay, state of Punjab, 67. 1967. What has happened is, okay, you can, Article 368 is there, but 368 is actually talking about the procedure to amend the constitution. Guys, listen this word very carefully. When it comes to judiciary, they will look into, only the words. The words are very important. Okay, so whatever written is very important. No emotions are there in the court. You will only look into the words. Whatever is written, it has to be followed. So they has been interpreted like this. It is a procedure to amend the constitution, but you cannot see any word that is the power to amend constitution. So in the Golaknath case, the judge held that you don't have the power. The procedure is there, but why the procedure is given? Procedure is given means automatically you have the power. But judge held that you don't have the power, although the procedure is there. Procedure is this, but you don't have the power to amend constitution. And it has been held that you cannot amend constitution, especially fundamental rights. So first case, Shangari Prasad case, held that you can amend the constitution, so the first amendment is valid. Golaknath case, you cannot amend the constitution. Now comes the parliament will react it with the 24th Amendment Act. Okay, in the 24th, guys, 25th also is very important, that I'll discuss when we discuss about DPSP, which is connected to more of DPSP. So 24th Amendment Act, what has been held is, it actually changed the very title of the Article 368. The Article 368 has been, in a way, I can say it amended the Article 368. Can you amend Article 368? Yes. Why? This is also an article. This is also part of Constitution, and Article 368 is a part amendment of Constitution. So they amended and they made it like this. It is a procedure and power to amend the Constitution. The procedure to amend the Constitution and the power to amend the Constitution. So they simply added the word power. That means now you have the power. But is it logical? Already this case has been said that you don't have the power to amend Constitution. Now this is another amendment. Since you don't have the power to amend Constitution, how can you amend the Constitution? And how can you add the word power? You have no power to amend Constitution, and you are amending Constitution, and you are adding is this legally valid? No. So it has been challenged. Under which case? That is a significant case. Just before also we have discussed Kesavananda case. Kesavananda case is very important for many, whether it is with respect to preamble, DPSP, or it is very important. Okay, even judicial review in many cases, the basic structure. Okay, so Kesavananda Bharati case versus state of Kerala. It has been held that what? The first one, the parliament have it. Kesavananda Bharati case upheld this amendment, and it went along with the parliament. Parliament won the case. In fact, Union of the state won the case. It's like this only. You have the power to amend constitution. Okay, so under Kesavananda Bharati case, under 368, you can amend the constitution. So these are the three important cases. So first, Shangari Prasad case, you can amend constitution. Golaknath cannot amend constitution. Kesavananda Bharati case can amend, especially fundamental rights. Okay. So these are the three cases. Kesavananda Bharati case 1973. So court upheld the validity of 24th Amendment Act and said that there is no problem. It also conferred the power to amend constitution, because anyway the constitutional makers have given the procedure, means automatically it implies that there is a power. Without giving power, what is the point in talking about the procedure, right? So but only thing it has been stressed on, this is also very important, but subject to basic structure. So here comes the basic structure doctrine. So when this basic structure doctrine is introduced in the Kesavananda Bharati case, amend the constitution. Now what is basic structure? Is that discussed in this case? No. It will be coming in different other cases. Like, what are the basic structure, guys? Many things, right? Secularism. In one case, my case, I don't remember which case, it has been held that secularism is basic structure of constitution. Supremacy of constitution, parliamentary form of government, socialism, access to justice, rule of law, federation, separation of power, sovereignty of India, all these are basic structure. And in the next case, you will see Minerva Mills case. Okay, Minerva Mills case, it has been understood that judicial review is a basic structure, okay, basic feature of constitution. So just remember these cases. Kesavananda Bharati, basic structure doctrine introduced. Minerva Mill case, this is also very important case. Minerva Mill case. Minerva Mill case, judicial review is the basic structure of constitution. Okay, guys, we don't have time to discuss all the fundamental rights. This is something which you need to do. I'm not going to do that. So right to equality, right to freedom, right against exploitation, religion. I didn't understood, Brinda, which is supremacy means constitution is supreme, not judiciary. Judiciary is basically to enforce the constitution. Okay, so guys, just look into all these fundamental rights. In that, when you see the equality before law, uh, yeah, do we need to discuss about rule of law once again? I have already discussed about rule of law, right? Nobody can be punished except for violation of law, and it has to be proved in an ordinary court of law. So that is a key principle of rule of law. Then this concept of equality before law and equal protection of law. When we talk about equal protection of law, it is a concept from USA. Okay, it is a positively worded concept, which means equality of treatment in equal circumstances. That means a juvenile and adult cannot be treated equally. That's the reason why you have a juvenile justice system different, and in case of adult also different system is there, right? So equal protection of law is talking about guys, there's the concept equals to be treated alike, unequals to be or equals to be treated equally, and unequals to be treated unequally. Ethically also correct, morally also correct, and that is what all about equal protection of law. And that is the reason why you can give this reservation. Why reservation is constitutionally valid? Because of this provision of equal protection of law. So equal protection of law actually give way to protective discrimination or the positive discrimination. That's what equity also. Okay, equity, yeah. So reservation policy is justified under equal protection of law. Is it justified under equality before law? No. Okay, so but when we talk about equality, this should be among equals. Okay, so the state should do something to uplift the unequal also. I'm not talking about individual articles, Article 15, Clause 1, 15, Clause 2, 3, 4. Please look into that. Okay. These all are very important. Okay, now with respect to this reservation, I've told you 15 clause 4 giving the provision for reservation. Actual reservation is coming in 16 clause 4, right? 16 clause 4 actually empowers the state to make special provisions in the favor of backward classes of citizen in case of public employment in the backward class, if the backward class is not adequately represented in government service. So two conditions are there. What are the two conditions? It should be a backward. Backward means how? Socially and educationally, not economically. Okay, socially and educationally. Now this economically weaker section is there. So here backward means socially and educationally, and it should not be adequately represented. It should not be adequately represented. Then there will be a, guys, there is also very important case here, but I don't know whether you need to know about this for prelims. Indira Sahni versus State Union of India, 1992. Okay, in this case, the legal position of reservation policy has been clarified by the apex court. It has been held that, okay, This case is related to, I hope you know about this OBC reservation of 27%. I'm not talking about the context here. This context is related to this Mandal Commission report and its implementation and all. They have understood that 27% of the community and population is backward, so they should be given reservation. And 20, we are talking after this, okay, after this reservation. I'm not talking about this Morarji Desai government and everything. Yeah. So in this case, it has been held that, okay, this 27% for OBC, it has been constitutionally valid. Okay, Supreme Court held that it is valid, but not for all. So they introduced a concept of creamy layer, right? So those who are the creams, those who eat the cream, okay, they should not get this, because they are not socially or educationally backward. They can get better education and all. So that creamy layer, that is based on income, that will be seen later. It can be that income ceiling is there, right? So it should be less than that. So OBC reservation is declared, fine. Right now 8 lakhs, okay, fine. Secondly, so this is one point. You can give reservation, but it should not cross 50% of the total seats. Okay, so this 27% is given, then SC reservation is there, ST reservation is there, but it should not cross 50% of the total seats. Then third point is very important. You should give it at entry stage, not to be given for promotion. Okay, and keeping this in mind, the Supreme Court has actually scrapped this reservation for SCs and STs in promotion. But what happened? Parliament passed the 77th Amendment, okay, 1995, and in that one provision was added. Which article? 16, clause 4. 16. 16 clause 4A. This was added, under which reservation is given in promotion for SC/ST also. So it is going against this one. Since this reservation has been scrapped, it has been another amendment was passed in through the 77th Amendment and given the reservation for SCs/STs in promotion as well. Okay, so 1, 2, 3. Yeah, these are the three things that you need to remember. So now, in 2006 also, actually the Apex Court clarified certain requirements. Around 5 requirements has been discussed, and I think we have discussed this in detail in the class also with respect to these requirements. Like what I've told you now, it has to be socially and educationally backward. Second, representation, it should not be adequate. Okay, so these two are very important that we have already discussed, and it should not affect the general efficiency. Just because you need to give reservation doesn't mean that, guys, let's suppose 3 posts are there, and one is reserved for one community, but only one person applied from that community who didn't even know anything about that, and he is scoring 0 mark in that. So should he be given this? No, right? So general efficiency should not be affected. What you can do for that? You can keep the cutoff, and in case if the candidate is not able to do that, keep that vacancy open and keep it for the next recruitment. Okay, then concept of creamy layer, and the reservation should not cross 50%. So these are the conditions which you need to remember with respect to this reservation. Now, untouchability, the titles, etc., that you please look into. Right to freedom, very important, please look into, because these two articles, Article 19 and 21, is the most widely and the most interpreted articles, okay, related to freedom and related to life. Look into this right to organization, associations, etc. Right to life include many, okay. So Lakshmikant, they have given a list of it. At least by seeing that, you will understand even right to environment, right to fair trial, everything is a fundamental right. Guys, what is the difference between procedure established by law and due process of law. So what this Article 21 says, no person shall be deprived of life and personal liberty except under procedure established by law. So that is what Article 21. That means if there is a procedure which is established by law under which somebody can restrict you and somebody can deprive you of life and liberty, then it can be done, right? So procedure established by law means if there is a law which is there which can deprive you from personal liberty, then it is okay. That means here the court will only check whether the executive followed what the law correctly. Whether the law in itself is correct or not is not checked. Now what is the assumption here? The legislature will make law in the good faith. That is the assumption. Okay, so the law which is made is in good faith and the law is correct. It's not like Rowlatt Act and all. It is not expected that the legislature or the parliament will make laws like Rowlatt Act, right? It is not expected. The laws will be made in the good faith. That assumption is there. And then if executive implement the law, it has to be follow the procedure. So if you follow this concept of procedure established by law, you will be protected from the arbitrary action of the executive, not the legislature. Why? Legislator make any law, the court will not interfere. Why? Because of the assumption of good faith. But if the executive, while implementing, not following the law, then the court will interfere. But if the executive followed the law, court will not interfere. It doesn't matter whether the law is good or bad. That's what procedure established by law. Okay, UK. Where on the other hand, USA, this concept of due process of law. Here, the court will not only check the procedure established by law. You have to first follow this. Then the court also will check the substantive nature of law, whether the law in itself is good or bad. Here, there is no assumption that the legislatures make laws in the good faith, right? Because this America, they have faced this problem, right? Many this various act which was passed by the British Parliament from here and implemented there. So the judiciary is always looking into the good faith of the legislature also. So that is why due process of law. Here, if you follow due process of law, it will check the arbitrary action of both executive, that means executive action, as well as legislature. Okay, the law also will be checked. The implementation of law also will be checked. That's the due process of law. And in which case, in which judgment? Maneka Gandhi case. Under Article 21, include due process of law. So before, if you remember, I have read it as Article 21 is related to nobody shall be deprived except on the case of procedure established by law. That means if there is a procedure which is established under law, then you can be deprived. But that's not the case. Under Maneka Gandhi case, it has been held that due process of law is also applicable under right to life under Article 21. So we follow due process of law as well as procedure established by. There is no point in telling procedure established by law. Once you're saying due process of law, automatically what will come? Procedure established by law will come. So if this is how, here it will check the executive action, okay, but excluding legislative action. But when it comes to due process of law, this and this will be taken into consideration. Guys, I hope this is very clear to all of you. And also, the Supreme Court has been interpreted natural justice as part of Article 21, right to life. What is natural justice? What are the key principles of natural justice? Nobody shall be punished unheard. Nobody in the world can punish you without hearing you. You will be given adequate opportunity to present any case. Okay, and nobody can be the judge of their own case. That means if you are fighting a case against someone, they cannot decide upon you. Okay, and only the court can decide. Thirdly, the authority should act bona fide. There should not be any malified intention with the authority. So I hope this is clear. So these are three key principles or universal principles of natural justice. Guys, look into this Article 21 clause 21A, the 86th Amendment Act, and this exploitation, religious related cases and everything, and 32 also. Okay, quickly we will discuss about the constitutional remedies under Article 32, or we will discuss types of writs. I hope this is clear. What is the difference between Article 32 and 226? 226 is related to High Court, right? So this is when it comes to the Supreme Court. Guys, 32 is applicable only for violation of fundamental right. Okay, that means this is narrow, only for fundamental right. Here, other rights also. If your fundamental right is violated, can you go to High Court? Yes. Okay. Other rights, yes. Other rights, definitely you have to go to High Court. Or if it is ordinary legal rights, based on that, you need to go in that way. It can be tribunal and High Court, etc. Okay. So here, fundamental right. But fundamental right is violated, you can either go here or go here. Supreme Court cannot send back to High Court if you are approaching the Supreme Court for violation of fundamental right. That in itself is a fundamental right for you. Suppose if Supreme Court is sending you back to High Court, then again you can challenge that in Supreme Court by saying that Supreme Court have violated your fundamental right. So Supreme Court cannot send back you to the other. But if you are approaching the Supreme Court for any other, like suppose you are removed from your job or something like that, you cannot go to Supreme Court. What you need to do? If you are a IAS IPS officer, you have to go to Central Administrative Tribunal. Then you need to go to High Court. Then you need to go to Supreme Court. Okay. So like that. If you directly approach Supreme Court, what will happen? They will ask you to go to High Court or Tribunal. Like that. So this is here it is narrow, here it is wider. Okay. So what we need to discuss under this one, we were actually talking about writs. Okay, yeah, here again Constitution places a duty on the Supreme Court to enforce fundamental right if it is found violated, right? So Supreme Court has to implement the fundamental rights if it is violated. And what about the territorial extent? If you look into entire India under Article 32, but here specific state, right? Not the territorial jurisdiction is limited. So here it is wider, but territorial jurisdiction is wider here. Okay. Now, what are the writs? Habeas corpus. I'm not writing it completely, guys. Habeas corpus means it is basically all these habeas corpus or mandamus or prohibition or certiorari, quo warranto. All these are the writs. Okay, Latin words. So here habeas corpus means to have the body or to produce the body. So this is the one which is most widely used. This is actually preventing from illegal detention. So if somebody or state is detaining you, okay, illegally, then you the locus standi means who's responsible for doing it or who's affected with this. So either you, obviously you cannot go because you are detained, and who will go? Your relatives or your friends can approach either the Supreme Court or High Courts. Yes, writ is a constitutional remedy. Okay, so you can approach the High Court or a Supreme Court and can release if it is. Then the Supreme Court will ask the state on what ground you have detained. Okay, so if they are not able to give any legal ground, and if it is proved that it is illegally detained, immediately they will order the release. So that is what habeas corpus. What about mandamus? Will be asking you to do something, right? And it can be passed only against a public authority, not a private authority. Okay, and even in case of a public authority, if the public authority can act in his discretion, then it cannot be done also. It cannot also be against a president or a governor. So issued for public or legal right, not a private right. Only with a public authority, not a private authority. Then this one, prohibition or prevention, prohibition and certiorari. Guys, certiorari means suppose some order has been passed. Okay, some judgment has been passed. If the higher court, the High Court or Supreme Court suppose Central Administrative Tribunal passed an order. So High Court find it is not correct, illegal, then can issue certiorari to quash this judgment. Similarly, High Court judgment can be quashed by the Supreme Court. So it is like a cure, right? It is cure means something which has been done, which is not correct. So to cure that, this has been done, certiorari. So you can remember this C and C. Similarly, prohibition means what? If you don't have this is a kind of prevention. Okay, if this is actually issued in case if you don't have the authority to pass any kind of judgments or anything, it is actually prohibiting you from proceeding further on the case. So you can remember this word, guys. Prevention is better than cure. So in case of prevention, you will issue prohibition, that you don't pass the judgment. Cure, you pass the judgment but it is not correct, so you issue certiorari so that you can quash the judgment. Here, stopping from issuing a judgment or acting further, here something which has been done, it is a cure. So just remember this, prevention and cure, PPCC, you can remember that. Cure is done, something happened, right? Certiorari. Prevention, before you do it, prohibition. I hope that is clear. Now, quo warranto means asking you what authority, what is your authority? So the purpose of this writ is actually to ensure that a person holding the public office is qualified to hold that office. If you don't have that qualification, then like if somebody is complaining you what authority you hold, it like that. Okay, guys. So what we will do today, right now, we'll stop here and we will resume tomorrow. I'll start with directive principles. Today, we'll not be able to complete that. Okay. Yeah, I will upload this. In case if you have any doubt, you can go through that also. See you guys.